As the court, please. The Honorable Court of the State of New Mexico.
Morning, can we see that? Thank you. May it please the court, MJ Edge for Gerald Lee Chavez. One moment, let me just call a case and absolutely. Give you 1 second here. All right, good morning. Calling S-1-SC-40017 State versus Chavez. We welcome for today students from Highlands. Petitioner, you have 20 minutes. You may enter your appearance and proceed.
Thank you, Your Honor. I am Matthew James Edge, and I am appearing on behalf of defendant petitioner Gerald Lee Chavez. I want to thank the court this morning for this opportunity to talk about the Constitution. I find this a really fascinating subject. And in discussing it, I'm going to use the terms magistrate and metro pretty much interchangeably. They're both magistrate courts, but more importantly, I think for this argument, these are both courts of limited jurisdiction, and that's really the key to interpreting the rules in this case. And that being the feature of a court of limited jurisdiction is that it has no inherent constitutional jurisdictional power. And therefore, all the powers that are granted to it must be explicitly granted. And we think that basically the rules make no distinction between a case pre and post indictment. So we think that under our Constitution, the severance of the magistrate court's jurisdiction over a case when it's transferred to the district court.
Can a magistrate strike that? Can a metro court judge sign a felony warrant?
Yes.
Now, jurisdiction to sign a felony warrant is different from jurisdiction to try a felony case. Is that correct?
They're very closely related. And let me say that there is, I think you're pointing to Sadlowski, which is a federal case that makes a distinction between the trial jurisdiction of a court of limited jurisdiction and its writ authority. And we have no problem with magistrate courts issuing warrants in the investigatory phase of a case, before the bind over of a case. And that's when a magistrate court exercises jurisdiction over it along with the district court case. What we're saying is that under the New Mexico Constitution, the exercise of writ authority has to be done pursuant to the court's jurisdiction. Our Constitution doesn't give writ authorities to courts unless it's to do something with their jurisdiction. So our argument is basically that once the magistrate court's jurisdiction is severed by transfer to the district court, it loses that power.
Where does it lose that power? Post-indictment. So you're arguing that no post-indictment warrants?
There's no post-indictment from a magistrate court, Your Honor. You can always go to the district court to get a search warrant, Your Honor.
Must you go to that district court?
That's correct.
Can you go to any felony court, or must it be the district court that has jurisdiction over the criminal case?
I'm sorry, Your Honor?
Can you go to any felony court, any felony judge? Or must you go to the judge that's hearing the particular?
So if there are, say, multiple judges in a district court, could you go to a different?
As happens under the case management order in the second specifically.
Right. I think that's fine. I mean, they're both officers of the same court. I don't know that there's the same problem that you would have from a judge from a completely different court one that has its own constitutional
So you-
powers and authority, I think that's different.
So your problem isn't with the fact that they didn't do a motion for standards as opposed to a warrant. It's simply that the Metro judge signed the warrant as opposed to some district judge somewhere else.
Well, I mean, these are kind of related questions. I mean, the district court judge wanted the motion for standards
Yes.
for her.
Yes.
Presumably, the other district courts judges would know that as well, and they would communicate it among
But
themselves.
you just
so
said
can
that they
decide-
could sign a warrant. You said any district court judge
Yeah,
could
they can
sign a warrant
yes,
during the pendency of the felony case, which is different than the process of filing a motion for standards.
Yes, Your Honor, that is different.
What is a motion for standards? It's been a long time since I practiced, but I don't understand what they're talking about here, a motion for standards.
So basically, instead of seeking a warrant, what would happen is that the state would simply file a motion with the court saying that we want the defendant available to provide this oral swab. And then there's a hearing on it, if the court grants it, then
But what, to what end? What purpose?
basically it's so that the district court can manage its own case management.
No. What's the purpose of getting the swab? There's a pending case. In this case, for example,
Yes,
what in the world is his swab, his DNA have to do with anything in the case?
Presumably identity is an issue, Your Honor.
Well, they wanted fingerprints, presumably. But there's nowhere in the affidavits, either affidavit, says anything about DNA being necessary in order to assist in the investigation of the identity of the driver of the pickup truck.
That's right.
But
Yeah.
what my question is this, is it seems like this motion for standards seems like something that everybody does in the district court. And I just don't understand why you would want to do that. It sounds like they do it in every case, and maybe I'm just being ignorant or timed out on the practice in criminal court, but I don't understand it.
Yes, Your Honor. I believe the practice, Your Honor, and I haven't done felony practice in the second district, so I'm not exactly familiar with the procedure there. I believe why they do this is that you have a case management order in place, and that under the case management order, discovery that would be obtained pursuant to a motion for body standards would be subject to disclosure much sooner than evidence that would be obtained pursuant to a search warrant.
Is that true, though? The deadlines are the deadlines, DNA scientific evidence. So regardless of where and when that evidence came, the deadlines still need to be followed. And I would be a little concerned about applying a different standard to the second versus jurisdictions that don't have a case management rule. I just don't see what prohibits the district court from enforcing those deadlines, irrespective of where or when the evidence came from.
Your Honor, I mean, it was a concern for them, and I think part of the concern is that it's not just when the evidence is turned over, but when it has to be disclosed. And I think this was a finding that was made by the district court, and, the parties, the state hasn't really pushed back against that. I think they pretty much admit that pursuing the evidence in this way will delay the case, and that seems to be their motive in trying to seek this search warrant rather than going through a motion for body standards.
But the court can resolve that under the deadlines provided by the CMO. If I'm understanding Justice Moore's question, or I'll frame it a little differently, still write a rule that says they can go to the magistrate for that warrant, but the timing of your disclosure of that evidence to the defendant is still regulated by the CMO.
Yes, Your Honor. I mean, the concerns of the district court could be addressed through amending the CMO. I guess the problem with trying to do it that way is that there is this constitutional order that we have in our state where we have a hierarchy of courts, and the higher courts are meant to supervise the lower ones. And in here, we allow this kind of jurisdictional inversion. We're allowing one of the parties to forum shop in a court of limited jurisdiction to get orders that will affect the management of a case in supposedly superior court that's supposed to have supervisory power over that lower court.
So why is suppression an appropriate remedy? What's the basis for this court, the district court, to order suppression? Constitutional or otherwise?
Yes, Your Honor. Jurisdiction, Your Honor. What we're saying is that without an affirmative grant of authority to issue a search warrant after a case is bound over to the district court, the magistrate court has no authority to issue a search warrant in a post-indictment case. So that would be the basis for her quashing this warrant, Your Honor. It was issued without jurisdiction, and consequently, the affidavit to the Metro Court judge omitted a material fact that this was, in fact, an indicted case for the district court.
So you're saying it's supervisory authority?
Yes, Your Honor. The constitutional order that's established, we have this court supervising the lower courts underneath it, and the Constitution gives this court writ powers in the full exercise of its jurisdiction, according to the language of our Constitution, and it gives district courts writ authority in the exercise of their jurisdiction, Your Honor. Now, interestingly enough, there is no jurisdiction for writ authority given to magistrate courts under our Constitution. That comes by dint of 38.1.1, which I've actually miscited in my brief as 35.7a. It's actually 38.1.1, and that's the practice, pleading, and procedure statute that gives this court authority to promulgate rules of pleading, practice, and procedure for lower courts. And it says practice, pleading, and procedure, and there's a proviso in it that the changes that this court makes in the rules cannot substantially enlarge or diminish the rights of any party. And so what we're arguing is that while it's okay for a district court to, or I'm sorry, it's okay for a magistrate court to issue a warrant in a pre-indictment case, after it's been transferred to the district court, it exercises exclusive jurisdiction over that case under our Constitution. There is no explicit grant of authority to a lower court to issue a warrant in that kind of case.
Give me explicit language in the rules of the Metropolitan Court, the rules of the district court, which says that.
It's not in the rules. You have to look outside the rules because the rules can't contain it, because that's simply the rules that are set up under 38.1.1 by this court for the Metro Court.
What body of law, what statute or constitutional provision do you believe deprives Metro Court of jurisdiction to sign search warrants?
It's not that there's anything that deprives them, Your Honor. It's that nothing that gives them that authority. That's the key. We're talking about courts of limited jurisdiction. So unless there's an affirmative grant of authority, there is no inherent judicial power that that court can rely on.
But isn't the
jurisdiction for that.
authority in the idea that the state has said that this limited jurisdiction court can issue search warrants?
Right, and that's certainly
But without limit. There's no limit on it.
the limit comes from the other provisions in our law, Your Honor. I mean, that's why we can't simply say we can't look at the beguiling simplicity of just referring to the language of the rules, Your Honor, because these exist within a constitutional order that places limits on them.
But why couldn't the district court say, I have jurisdiction over this case that's now been indicted. I have jurisdiction over this case. I am managing this case. And you went out and got this evidence without letting me know about it. And in my supervisory capacity over this case, just like Brady material or any other information obtained in violation of the court's order, say, I'm not going to allow that to be admitted. But that's not constitutional. That is the court exercising its authority over that case.
Yes, Your Honor. That is, The district court does have the power to administer cases, but
and order and allow evidence to be admitted, or preclude evidence from being admitted, which is obtained in violation of its own scheduling order or other orders.
yes, Your Honor, and that is an alternative basis for affirming in this case. But we're saying that more than that, there is a constitutional problem with allowing the state to essentially go behind the district court's back and seek these kinds of warrants from courts of limited jurisdiction. And the infirmity with that is specifically constitutional.
Would it be okay if the district court said, I don't have time to handle your discovery matters, go ask the magistrate court?
No,
Why?
because the district court can't delegate that authority, Your Honor. This would be something that we could do if our magistrates were like federal magistrates. In that case, the magistrate wouldn't be a judge even, and they would just be a judicial officer hired by the district court to do tasks given to it by the district court. Our magistrates are something entirely different. They are constitutional officers in their own rights. They have their own courts. So I don't think that you could simply, the district courts couldn't delegate that back to the magistrate court any more than it could delegate, say, the trial of very low-level felonies back to the district
So is it
court.
your position that basically by operation of law, the minute the case is bound over to district court, the authority of the magistrate court to that case terminates in its entirety?
Yes, Your Honor. I mean, it's not really so much the operation of law so much as it is the nature of our Constitution.
Right, it's by operation of our Constitution.
Yes, Your Honor.
So let me press you on that. Let's assume that the state, the prosecutor goes to the district judge, says, I'd like a search warrant. Can I go to the magistrate court and get a search warrant? The district judge says yes. Same result?
Okay, so first of all, is this pre or post indictment?
Post indictment.
Okay, and I go.
And the prosecutor in this case goes to the judge and says, district court judge, and says, we'd like to get a search warrant. May we? And the district judge says, yes, you may get a search warrant from the Metropolitan Court.
No,
Are you saying there's no jurisdiction?
you can't do that, Your Honor. It's for the same reason that we couldn't delegate. Once it's indicted, that case belongs to the district court, and it cannot redelegate any aspect of that court back to the magistrate court.
So Twyla Muse, which is a case I'm a little bit familiar with, cited in the briefing, says this, that after an information that was cited by the district court in her order, after an information is filed in the district court, an identical charge or charges pending in the magistrate court should be abandoned. Doesn't say they have no jurisdiction. In furtherance of the interests of orderly procedure, judicial policy mandates against piecemeal prosecutions growing out of the same act or incident. It's not dealing with search warrant, it's dealing with charges being pending in both courts at the same time. But it doesn't say it's a matter of jurisdiction. It says that it should be in the interest of the orderly administration of justice. It seems to be contrary to your argument that it's jurisdictional.
Your Honor, first of all, I would say that was simply dicta. There was for that case. Secondly, I would say that
Wasn't dicta, I can assure you that. Because the argument was that it had to be in Metro Court.
yeah, well, I mean, I would say that that is not really the case. I mean, you're talking about, first of all, I'm not really sure. I mean, did they go ahead and pursue those charges? I mean, did they take the hint and drop them, or did they take I mean, I think that the resolution of Muse, it wasn't necessarily had to do with charges that were pending and we're also talking about cases that, or I'm sorry, charges that the magistrate court would have jurisdiction over in its own right anyway, because they're non-felony charges that are dealing with a felony case. I think that this court could make rules, a rule under 38.1 under pleading practice and procedure that would resolve that question without it being constitutional, Your Honor. This court could simply say that, you know, when things are bound, they could simply redefine when things are bound over, right? And if there are pending misdemeanor charges, this court could simply make a rule that says that those could stay in magistrate court or that those could come up. So I don't know that that's necessarily contrary to my position. I think it does speak to the power of this court, Your Honor, in as much as you are the final authorities for the interpretation of the provisions that are under discussion today. So, you know, I mean, I think if you find that it's not jurisdictional, then I would have a hard time arguing with you. But I'm saying that the language of our constitutional text makes these kinds of limitation on writ powers absolutely important. And it is one of the key and distinct features of the New Mexico Constitution. And I would ask this court to heed that language. And I see that my time is up. If there are no further questions from the court, I will speak to you again, rebuttal. Thank you.
Thank you, counsel. We hear from the state. Enter your parents' counsel. You have 30 minutes.
Good morning, Meryl Francolini on behalf of the state, and may it please the court. I think I'm a little shorter than Mr. Edge, so hopefully everyone can see me. The Court of Appeals was correct that the Metro Court didn't lose jurisdiction to issue a search warrant when the defendant was indicted. There are several considerations that support the court's holding. The first and foremost is the language of New Mexico's warrant rules. But beyond that, we have the policies underlying our state's strong preference for search warrants, some practical implications that are at play in some of New Mexico's judicial districts, the clear separation between a court's trial jurisdiction and its authority to issue search warrants.
Why is that distinction important?
It's important because I think the district court erred when it equated the two, and it assumed that when it acquired trial jurisdiction over the case, it also acquired exclusive jurisdiction or authority to issue search warrants, and that's just not the case.
Why not?
Yeah, I guess I understand that point. I guess I'm looking for a reason why not. That is, it does appear to me, I read the rule in the way you do. It does appear to me if a trial court is taking jurisdiction over the criminal action, it should include everything, including warrants. But why is it important in our judicial system to have this separation between? Is it because it's a probable cause standard and, you know, district courts are handling felony matters? Why is it important of that distinction?
There's a couple reasons, and to sum it up most easily, I think I'd point to the cases out of other jurisdictions that have addressed the issue, and they primarily rely on the fact that search warrants are investigatory in nature. They're available to law enforcement really at any time, regardless of the status of a case, because they're aimed at gathering evidence. There's no guarantee that that evidence is going to come in at trial, so they're not necessarily part of the case that's pending in the trial court. And I don't think the district court has.
But shouldn't the district court have the authority to direct how that evidence is gathered? And shouldn't she know what's going on in the case rather than having investigators going around her back for lack of a better phrase, and her not knowing how this investigation is going and how her case is proceeding?
I think generally the district court doesn't have much authority to kind of control on the front end how the state is collecting evidence and preparing for trial, but it certainly has authority when it's time to decide whether the evidence come in.
And
so there's always that. Sorry, I'm sorry. Go ahead.
No, to Justice Vargas' point, that here you had a pending motion to quash in front of the district court judge.
Sure.
And then there was a race back to Metro Court to go around that. And to me, fundamentally, that's not how our system should work. It creates piecemeal litigation, judge shopping, all kinds of things. Like, well, we're going to make sure we cure our error by running away from this and going to Metro Court and making the same misrepresentation that was made the first time, yet again, to the Metro Court judge. And so to me, that is at the heart of what bothers me in this case.
Sure, I understand the court's concern. Unfortunately, I can't speak to what the trial prosecutor, what his methods were motivated by. I wish we had more information in the record about exactly why it was done this way, but I certainly understand the appearance of it all. There's been a suggestion that this kind of practice is forum shopping, but I fail to see how that's so, just on the basis of Rule 7208 requires the exact same things of the Metro Court before it issues a search warrant than Rule 5211 does of a district.
Except for
court. So-
what happened on the ground in this case. I think the fact that there was a motion to quash. And so you race and get another warrant and get what you want without having to address the motion to quash. That's forum shopping between Judge Leos and whatever card you draw in Metro Court. Maybe not at the front end, but here it was. Based on agree there's limited facts here, but there's only one conclusion to draw from. I'm going to go do it again. I'm going to make the same misrepresentations that I did. I'm going to get a third judge involved in this, and they're going to give me what I want, even though there's a pending motion in district court.
And all I can conclude in good faith is that
And I get you very.
the prosecutor believed that there was nothing unlawful about the practice of getting the warrant from the.
Yeah, I just think those facts undercut this.
Sure,
This isn't
I understand.
forum shopping.
The way it all played out is not ideal. That's for sure. But when we get to the heart of the legal issue, I think the plain language of the warrant rules is really important in this case because it is the ultimate indicator of this court's intent and the intent of the Rules Committee in promulgating the rules. And I think Mr. Edge and I sort of agree on where the plain language gets us initially, but then we diverge on what do we do after that. But it's still worth a deep dive into the language because it is so important in this case. So Rule 7208 gives the Metro Court very broad authority to issue search warrants. It says that a warrant can issue for a criminal offense or any evidence in a criminal prosecution. So that's really any crime. It's not limited by crimes within the court's trial jurisdiction or outside of it. It's not limited by pre-indictment versus post-indictment. The only time limit that's expressed in the rule is actually for the execution of warrants. There's no limit saying that the court can't issue a warrant post-indictment.
But you can't lie in your affidavit.
I don't think the
And
answer
if you
lies.
can lie by omission and not, can you imagine telling this either Metro Court judge, this case is pending in the district court on my indictment that I obtained based upon my demonstration of probable cause to my grand jury. And I want a search warrant, Judge, and I'm not telling, and I haven't told the district judge who's in charge of the case that I'm here getting this search warrant. Can you imagine a Metro Court judge issuing a warrant under those circumstances?
I can, because
Really?
I don't see what the fact that the case was indicted, how that would have affected the probable cause.
Well, because, and then the second judge, Judge Dominguez, being told, I went to get this without telling the district court judge, and I got it from Judge Alanis, and then they filed a motion to suppress, and now because I didn't get that in time, now I'm here again, and I'm not telling either the judge or defense counsel or anybody else that I'm here to get a search warrant.
I think those
Don't you have
facts,
an obligation to serve opposing counsel at least with that request for the search warrant? When the case is indicted and the defendant has counsel.
well, there's case law that says that a search warrant is not a critical stage of the proceedings, and that doesn't change after indictment. The state is not precluded from gathering evidence because a person has been indicted.
Nobody's saying that, but you do it according to the rules.
And it was done according to the rules in this.
Well,
case. The
I think-
appearance of things was a little off, certainly, but the rules for Metro Court have no language, not even a hint of anything precluding this. As far as the affidavit goes, I think best practice certainly would have been for the officer to include all of this information. But the trial prosecutor below argued that it actually kept the affidavit a little more fair on its face to leave out the fact that the defendant had been indicted. Because what that would have signaled to Judge Dominguez is that one of her colleagues had already found there was probable cause for this person to be charged. That could.
That was a grand jury finding probable cause, not a
Sure.
judge.
But it could have swayed potentially in the wrong direction.
I'll ask you another question. I
Of
don't,
course.
so as I understand the rules in the Second Judicial District, local rules, once a judge has refused to act on something, you cannot go ask another judge for the same relief.
Are you like a law of the case kind of?
No, you ask a judge to sign an order and the judge refuses, or that you ask for whatever, and the judge says no.
Mhm.
You cannot go to another judge and ask for that same relief. Now, if you've got a motion pending before a judge asking for relief, under the logical extension of that is you can't go ask another judge for the same relief that is your now already requested from another judge.
That might be true. I think technically at the time the second search warrant was issued, Judge Leos had not actually ruled yet, I believe.
She had the case though, but the motion was pending before.
She did have the case, but again, her trial jurisdiction doesn't give her exclusive authority to issue a search warrant in a case.
But the defense here had filed its motion to quash that first warrant from Judge Alanis
Yes,
before the defendant went, or before the state went and sought its second.
yes. And again, I am stuck with not a great set of facts as far as how this all played out in real time.
So can I ask you, I want to make sure there's the constitutional issue. I believe the due process claim was abandoned. But I want to make sure something you said earlier, the district court entered its scheduling order within 30 days of arraignment. It had a scientific evidence deadline. Is there anything that would have precluded the district court from enforcing that scientific evidence deadline because this evidence was obtained through a warrant as opposed to a motion for standards? Is there any reason why this deadline could not be imposed regardless of where and when the evidence came from?
That's a great question. And I don't know enough about, like Justice Vigil, I don't know anything about motions for standards. I tried in researching in preparation for this argument to find some rules somewhere. I couldn't find anything. So I don't know if when those motions are granted, there's some kind of ruling that implicates whether the evidence will be admissible at trial. But I think had this warrant just been issued by the Metro Court right out of the gate, and we didn't have this issue of kind of this appearance of sneaking around on the part of the state, I don't see anything that would have allowed the district court to suppress the evidence if it was disclosed prior to the deadline.
And I'm saying if it's disclosed after the deadline, whether it's,
After, okay.
and I will tell you this, I'd never seen anything like this. We had motions for standards all the time. I'd never seen them go get a warrant from a lower court, but not saying and commenting on the legality of it. It was unusual to me. I can see how Judge Leos thought this was very unusual.
Sure, and I haven't seen it either. I've never done felony prosecutions in the second, but I haven't seen it. I think one thing that's important to remember is even if this court decides today to allow generally the Metro Court to issue post-indictment search warrants, we do still have that safeguard of discovery deadlines. Had this been disclosed too late, Judge Leos could certainly, I believe it's a three-prong analysis of a different kind. It involves an inquiry into prejudice. She certainly could have suppressed the evidence.
And it's interesting in looking at the case, none of that is here, right? I mean, I think you're getting a general sense that we are not real thrilled with the way this was done, right? Sneaking around, whatever you want to call it. I mean, you can go to any matter of degrees. But the way this was appealed, that was not what these decisions were based on. The question we're asked is, does the Constitution remove authority like federal removal statute? Did it violate due process? And was the affidavit inferred? From the record, is there any indication that there was a decision by the trial court to suppress this based on the conduct of the behavior of the violation of the local rule?
No, the court's grounds for suppression primarily was what it viewed as the loss of jurisdiction by the Metro Court upon indictment. And then the due process concerns were also addressed. There was some reference to LR 238.
There was, but the
kind
due
of an
process
afterthought.
concerns don't seem to be carried forward here. Do I have that wrong?
No, Your Honor, you're correct.
Okay, so I'm just trying to understand what we were asked to look at.
Sure.
Okay.
Our position primarily today is that the plain language of the warrant rules does not preclude the Metro Court from issuing search warrants in post-indictment cases. And we have all these other considerations beyond that that bolster the Court of Appeals holding. If this court is concerned, as I think it is, about the way this all played out, I think the opinion could be written to perhaps express a preference for motions for body standards, and express that if a case has been indicted, that fact does have to be included in an affidavit when a warrant is sought from a lower court. So
Does it matter at all that because this is already been bound over, defendant is represented by counsel? Does that being represented by counsel change this at all? Just in terms of, I guess maybe it's that's more of the due process argument, but it seems different in that somebody's now represented in a case, not like, oh, I think I might be indicted, represented.
Yeah.
Which doesn't happen very often, but does that make a difference?
I don't think it makes a meaningful enough difference to find that the issuance of a post-indictment search warrant for DNA is somehow unlawful or unconstitutional. There's case law out there, and I apologize, I don't have any of it in my outline here, but I specifically recall reading cases from other jurisdictions that found that the issuance of a search warrant isn't considered a critical stage of the proceedings, even if it happens after indictment, because it's still just investigatory in nature. There's no guarantee that this evidence is going to be used against a defendant at trial. So while he gets certainly more benefits when a motion for standards is filed, it's not per se unlawful for the state to use this other route to collect the evidence. And
As long as that probable cause was.
exactly, as long as there's probable cause, it's issued by a defendant.
Where's the probable cause for the saliva?
That's
I don't understand. I read this thing twice, and while I'm on that, the warrant also asks for latent fingerprints. How do you get a latent fingerprint from a defendant?
I don't know enough about latent fingerprints to answer that question, but I think Your Honor mentioned during Mr. Edge's presentation that maybe this is just a standard thing that they do in most felony cases now. I think you're probably correct.
There's no probable cause that I can see to get this man's saliva
Well, I would point,
under the search affidavit.
I think inferences can be drawn from what's in the affidavit, that there was physical evidence found at the scene, like a firearm and a magazine, and maybe we need to match the fingerprints. I would also
Of
point
saliva.
DNA, right. So there's actually a statute in New Mexico, the DNA Identification Act, that requires every adult who's arrested of a felony or arrested for a felony in New Mexico to submit their DNA.
So they get it at the jail. You don't need a search warrant.
I think if you are planning to introduce it at trial, it's better for you as a prosecutor if it came in through a search warrant rather than a warrantless search at the jail. So that may be the distinction in the prosecutor's mind. But I would like to talk about the plain language of the rules because I do think it's so important in this case. And it's very telling. So the language is very broad. There are no limits written into it. And this is important when we compare Rule 7208 up against other rules of procedure for the Metro Court, because those limits are written into some of the other rules. There are other rules where the Rules Committee in this court explicitly, in no uncertain terms, divests the Metro Court of its authority to act after a certain triggering event. So just as an example, I would point to Rule 7401, which governs pretrial release in the Metro Court. And it says that on the filing of a petition under this paragraph, the Metropolitan Court's jurisdiction to set or amend the conditions of release shall be suspended pending determination of the petition by the district court. So this is a very clear, concise expression of when X, Y, or Z happens, Metro Court is done and it cannot act any further. It has to defer to the district court.
So, but under your literal reading of the rules, let's assume a motion for standards or whatever it is filed in the district court and denied. Under your literal reading of the rules, the prosecutor can still go to the Metro Court and get a search warrant.
I think they could, unless the concept that Your Honor brought up earlier would apply. And
Why would it not apply? It's both are the same probable cause standard. A motion for standards is basically the district court's opportunity to see if there's probable cause for the swabs. I think Justice Vihil's question's right. I would be concerned if the court denied that, made that determination, and then they went across the street and had a Metro Court judge sign something that the district court had already denied. It's the exact same issue.
I agree with you. And I think, again, I don't know enough about how the motion for body standards works and what the analysis is that the district court has to go through. So I don't know if there's a required showing of probable cause, but I would agree that if that's the standard and the state doesn't meet it in the district court, they then they would be precluded just based on
what?
law of the case or something adjacent to that. I don't know
There's a
exactly,
rule
but
that says exactly what the senior justice said, that if a judge denied an issue like a search warrant, you can't go to another judge. So the local rule prohibits that. I don't see why it wouldn't prohibit this motion. If a judge denied a motion for standards for fingerprints, and then they went across the street and said, we want a search warrant for fingerprints, it's the same issue. There's a local rule on point, as the senior justice pointed out, which I think would apply here.
I would agree with you that if that's what the local rule says, that the state would be precluded from going to another court and seeking the warrant. That would certainly be a much worse appearance than.
Except can a local rule from our rules? I think the answer is no.
I don't think so. I think this court,
Rhetorical question.
this court gets to control the Metro Court by implementing rules of procedure, and it has implemented these rules that don't preclude what the Metro Court did here. And I know that Mr. Edge's position is that there needs to be this affirmative grant of authority to issue post-indictment search warrants, and that's what we need to look for in the language of the rules and in the law. But that's not really the case. This court issued an opinion just last week in State versus Vasquez, authored by Your Honor Chief Justice Thompson. And in that case, you were answering the question of whether district courts have jurisdiction and authority to sua sponte raise suppression issues. And what Your Honor looked at was the plain language of Rule 5212, the suppression rule, and the broad language in New Mexico case law. And Your Honor wrote that that broad language doesn't reserve to appellate courts the authority to sua sponte review violations of a defendant's fundamental rights, and noted that the suppression rule is silent as to whether a court can initiate a hearing on its own motion. And so the outcome was that district courts do have jurisdiction and authority to raise these issues sua sponte. And I think we should take the same approach to the language here, rather than assuming that we need an affirmative grant of authority. We can look at the broad language of 7208 and 5211 and their silence as to whether this practice is explicitly prohibited. And it's not when we look at the language.
Can I ask you a completely different question?
Of course.
The court of, so I assume that your prayer, I know your prayer for relief is just affirm. I am troubled by the Court of Appeals' reliance on federal case law.
Okay.
Because the federal court system bears no resemblance at all to our system. The magistrate judges are their employees, essentially, and they're charged exclusively with that warrant work. I know district court judges around the state would rejoice if that was the case here. And so it's a really different system. So relying on those cases seems to be problematic, regardless of, kind of the ultimate result here. Is that something kind of no matter that we should clarify? Because I am troubled by the fact that the Court of Appeals equated our system of magistrate court to the federal court system, and they're apples and oranges.
So the first thing I think is important to note is that the committee commentary to the warrant rules says that they're patterned on the federal rule. And then although the structure is a little different, at the end of the day, it just goes to show that there's nothing inherently wrong with allowing a magistrate judge who doesn't have trial jurisdiction over a case to issue a post-indictment search warrant. So that's really what the state relied
The
on.
appeals landed there. They made it a much broader proposition.
That might be the case, and this court could certainly clarify that the only similarity that's really of consequence to the
That trial
analysis.
versus
Exactly.
investigatory.
And that's what the state relied on in briefing. It wasn't to say, we should do exactly what the feds do, because I know we tend to depart from federal precedent quite a bit. But the core of it is that magistrate judges in the federal system, they have no authority to try cases. All they can do is issue warrants and a couple other preliminary matters, but they still can issue these post-indictment warrants related to cases that they have no trial jurisdiction over. So that helps illustrate the difference between trial jurisdiction and authority to issue a search warrant. So because the rules are pretty clear on their face, the language is broad, the Metro Court's authority to issue post-indictment search warrants isn't restricted, we should refrain from further interpretation, but there are several other considerations we can look at, even if we go beyond the language. The policies that underlie New Mexico's strong preference for search warrants, I think, are the most important. The Court of Appeals has previously said that we should interpret these warrant rules in light of those policies. And one of those policies is to provide a property owner assurance and notice during the search. That policy remains intact and honored if we allow Metro courts to issue post-indictment search warrants. The Metro court still has to follow all of the same requirements that the district court would. Law enforcement still has to execute the warrant properly and give the defendant notice during the search. So that policy is honored.
Would you agree that the subject of the warrant under the district court procedure of going and getting a motion for body standards and order on that motion actually would give more process and protection to the defendant? So that policy really doesn't hold up in a circumstance like this.
I would agree that a defendant would certainly be entitled to more process if a motion for standards were filed. I would point to, as kind of an analogy, the difference between grand jury proceedings and a preliminary hearing after the filing of an information, both of which are considered valid ways for the state to initiate a prosecution, but the levels of process and protection due at each are arguably quite different. Grand jury is really conducted in secret. It's a lay jury making the probable cause finding versus if the state were to file an information and have a preliminary hearing, the rules of evidence apply. The defendant is entitled to call witnesses. So the protections are much higher, but the state is still able to choose either avenue, essentially. So one avenue isn't kind of overburdened and backlogged. But again, if this court wishes to express a preference for motions for body standards in its opinion, I think that would be appropriate. There are some practical considerations that I'd like to touch on. I actually have a copy of the Second Judicial District Court's warrant rotation that they disseminate to local law enforcement in Bernalillo County. And it's certainly not in the record, but I would just like to reference it if the court would indulge me. It actually says on this document that goes out to APD and state police and the Bernalillo County Sheriff's Office that the following warrants should first go to Metropolitan Court. And it lists a few categories and DNA is one of them. So
But
this
that's not in the pending case.
It doesn't make
So
any distinction.
these warrants, correct me if I'm wrong, these warrants were both relate to the case pending before Judge Leo's, not some other third case or other case. It's this same case. So what you just read has nothing to do with whether or not it's pending before this, in the same case.
There's no distinction in this policy, so there's no direction to officers that if the case is pending, they have to go to the district court.
I understand that.
It's a practical concern that they're gonna have to pick up the phone and try and reach Judge Leos, and it's
That's,
not possible.
yes,
You
that's,
can- Council, that's why I asked, council said you can go to, how many judges do they have in the second now?
many.
You can go to any of the 12 to 12 to get that warrant.
Sure, and that works in a district like the 2nd. It doesn't work in a district like the 10th, where we have one district judge, Judge Rose, overseeing 3 counties. He's the only district judge in those 3 counties. And by contrast, there are 3 magistrates, one for every county. So if we tell Judge Rose that he's the only person who can issue a post-indictment search warrant, then he doesn't get to go on vacation. He can't get sick. He's essentially tethered to his phone and email. So we're proceeding as if every district is the 2nd and we have many district judges to choose from. But there are quite a few districts in New Mexico, rural jurisdictions, where we have 2 or 3 district judges. So it could, I don't think there's a flood of post-indictment search warrants, but it could create complications in these more rural jurisdictions.
You remember Judge Blackmer?
The name sounds familiar.
He was available 24/7. It didn't matter. He'd come to you in his robe and look over the warrant. He'd make changes to him. And the police officers really loved to go. They knew exactly where he lived. Let me put it that way.
My office has learned in conversations with the Bernalillo County Sheriff's Office in preparation for today that sometimes when they call the after hours warrant number, they have no idea who's going to answer. Sometimes it's a Metro judge and that's the only person available to them, or the district court judge who's on call won't answer their phone. So there are some considerations that we need to think about just beyond the 2nd Judicial District. So I see I'm just about out of time. So to wrap up, Metro Court has authority under our law to issue post-indictment search warrants. And for that reason, the Court of Appeals should be affirmed. Thank you.
Thank you, counsel.
Mr. Edge, 10 minutes, rebuttal.
Thank you, Your Honors. I just want to point out that the state's reliance on Vasquez is incredibly misplaced. They're absolutely right to point to the language in Vasquez talking about the inherent power of a district court. And that's because the Constitution gives them these inherent powers. They are courts of general jurisdiction. And that is the crucial distinction in this case. When we talk about Metro and magistrate courts, we are talking about courts of limited jurisdiction. Constitutionally, that means that they have to have an affirmative grant of authority in order to do something. What the state is trying to say is that they have these rules and they're not subject to any sort of provision in them within the language of those rules themselves that would limit them. What we say is that you have to look at the law as a whole. If you look at the constitutional structure of New Mexico, you would see that this kind of thing is just not the way that we do things. So their reliance on federal authorities, their reliance on out-of-state authorities that have completely different judiciaries would not be a good guide for this court. And moreover, I want to point out that the state is the party here in this case that wants the new rule. This is a case of first impression. No one before has ever decided to go back to a magistrate court to forum shop for a warrant before. And we've never had a case like this before because it's been understood that once you have the indictment jurisdiction is transferred to the district court, and that's where you need to go for your search warrants.
Yeah, I don't know if it's all, I mean, I think we're here because we had some slightly improper activity allegedly by the prosecutor and sort of going around, but this does seem, it is a compelling, you have a compelling argument in the 2nd. But if we were to write the rule that you're asking, no post-indictment warrants, unless it's the felony, I'll call it felony judge, the district court judge, in small districts, in rural areas where law enforcement is pretty far away. I mean, the first, for example, something near the Colorado border, you need to get a hold of a magistrate, although most things can be done telephonically. Is there, writing that rule, can you see the practical concerns with that?
Well, Your Honor, first of all, I would say, I mean, there have always been logistical concerns, right? I mean, in terms of the administration of justice, and I am aware of that. I would say in terms of judges reviewing search warrants, that's really not a problem. Judges routinely review the warrants that they've issued, right? In every state of the union which doesn't have courts of limited jurisdiction, you only have district courts. You have to go back to the same judge pretty much that you got your warrant from and argue in front of them. So that's not really something that implicates any constitutional concerns. I don't think that really implicates any logistical concerns. In terms of being able to find someone with the authority to sign a warrant, I mean, that may be a problem in that you have like one person as opposed to like four in a rural area that would be available to sign a warrant. First of all, we're only talking about post-indictment warrants. So you've already got a case that's been bound over to the district court, and you have a district court judge who is directly supervising that case. So, you know, that gives you a point of contact to go to in terms of getting a warrant to begin with.
Could we decide this under the third theory, law enforcement left out critical information from the warrant and announce a rule that's part of that critical information is you just had this suppressed. You have a pending motion to suppress in another court. That is information that judge has authority, I suppose, to sign that warrant, but critical information is, material information is, the same information is either available through a different means or there is a pending motion to suppress.
Yes, Your Honor. And also I would say that at this point, I would say that this situation also points out the difficulty with allowing the state to go back to the magistrate and seek warrants. You know, you have a district court that's in control of the case, and you have the state trying to find another judge who will sign an order that will upend the district court's supervision of the case.
Could have done that with a different district court judge, presumably.
Presumably, yes. But I mean, the difference there is that it's the same court, and administratively and politically, those two judges being in the same court have ways to resolve their differences that
Constitutionally,
court and magistrate court may not, Your Honor.
Constitutionally, one district judge cannot overrule another district judge.
I don't think
District judge has no constitutional authority to overrule another district court judge.
I don't think so, no. I mean, I think typically what happens is that district court judges give rulings that are at odds to each other, and then they're brought up here, and these differences are resolved, Your Honor. All right. Also, I did want to address your question about piecemeal litigation and pending litigation in magistrate court after the transfer. And I think the critical distinction here is that we're talking about charges that a magistrate court would have independent trial authority over. We just don't want them exercising it because these are attached to felony cases that are before the district court. And there is an issue regarding that in terms of piecemeal litigation. And I do believe that this court has the authority under 38-1-1 to promulgate rules that deal with that situation, to resolve that whichever the way the court would see fit, either to have those pendant charges go with the felony to the district court, or to allow them to remain in magistrate court and be tried there. That would be something that this court would be allowed to do. But I would distinguish that from the jurisdiction to issue a search warrant. And that is something which, under our Constitution, it is something that is granted by writ powers, specifically in those constitutional provisions where this court and the district court are given writ powers in the exercise of their jurisdiction. And I think that 38-1-1 might be a poor vehicle for expanding the jurisdiction of magistrate courts to issue search warrants, Your Honor.
So if I'm understanding what your argument is, and correct me if I'm wrong, if the district court learns that there is an affidavit for a search warrant filed in the metro court over a case that it is managing, it has jurisdiction and has authority to issue a writ against the Metro Court judge not to issue the warrant. Is that what you're saying?
I mean,
You're saying
typically,
writ authority.
right, I mean, so I guess I'm thinking of a search warrant as a writ. So,
Okay, my mouth just hung down. A search warrant is a writ?
it is a type of writ, Your Honor. It's a very common standard one. And you'll see in the briefing, we see a number of cases where it's referred to as a writ of discovery. And it is an order to a governmental actor that would allow them to do something that would otherwise be illegal. So I mean, that's pretty much what a writ is. So what I'm saying is that under our Constitution, certain courts have writ powers, but our Constitution always conditions that to be in the exercise of their jurisdiction. Simply what we're saying is that once you sever jurisdiction from a court of limited jurisdiction, there's no inherent judicial
I
power.
think I understand your argument now.
Right, thank
To
you.
me, a search warrant has always been called a search warrant. It's never heard it called a writ, but I learn something new every day. Thank you for that.
If there are no further questions from the court, I will yield my remaining time. Right.
Thank you, counsel.
Thank you, Your Honors.
I'd like to thank petitioner and respondent for their briefing and oral argument today. Appreciate the thoroughness of both. Appreciate the attention and courtesy of our students that have visited us. And in the matter of S-1-SC-40017, State versus Chavez, this case is deemed submitted and the court is in recess.